You're looking live now at the White House. President Trump is celebrating after his tariffs were reinstated yesterday. The appeals court says the tariffs can continue while it considers the case. Now, the White House claims that the two courts that put a pause on those tariffs originally were abusing their powers. In the first ruling, judges appointed by Presidents Reagan, Obama, and even Trump himself unanimously agreed that the president acted illegally when he declared a national emergency over the country's trade deficit. The second ruling says the president overstepped his authority. The Justice Department is already appealing and are calling for the Supreme Court to take over the case.
They also probably see how ridiculous this ruling is, and they understand that the administration is going to win.
Experts agree that the Supreme Court will ultimately decide this case.
We want to bring back our chief legal analyst, Khalif Rhodes. So every day we've had a little different story, right? Lower court said you're overstepping your boundaries with the executive powers. The appeals courts, what if the lower court said you're overstepping your powers, and the appeals court said no, we're going to let you have temporary, we're going to let you continue this? Where's the legal issue? Because they're both looking at the same legal issues, right? Why does one court say one thing and the other something different?
There's legal issues all over this thing. So let me go and say a couple things. Courts have an excellent way of sometimes making things that are unclear crystal clear. And they've done this here, but it's not crystal clear. It's probably as clear as mud. So let me try to help folks out as much as I can. When you're looking at a situation like this, the lower court, the original court, listened to and looked at the substantive issue. They had a full hearing. They determined, okay, this is exactly what we're looking at. We're looking at briefs. I looked at both sides. We'll listen to arguments, and then we'll go forward. I'll make a determination. Then instantly after that, I mean, within a 24-hour period, the Trump administration goes to the Court of Appeals, and then they have an emergency hearing. An emergency hearing to say, well, should this lower court's hearing stay in place while we decide the full merits of the case? And they said to that question that, yes, we'll allow that lower court's ruling to be lifted. We'll allow whatever Trump put in place to continue to stay in place while we decide the case on the merits. This isn't even an injunctive portion. This is just a request for an emergency relief, which is even faster and quicker than the extraordinary relief that comes from an injunction. So what does that get us now? It gets us to June 5th and June 9th when the court said that both sides have to submit their full briefs to that full Court of Appeals. I think ultimately at that time, once it goes in front of the Court of Appeals, and they have both sides' entire briefs, I think they'll rule the same way as the lower court did. But basically, they gave them this opportunity to say that there will be no irreparable harm if we allow these to stay in place. So ultimately, when they listen to the facts on the merit, and that's to your overarching question of, well, if they're looking at both facts, no, they're looking at this second court saying, well, won't there be harm if we allow this to stay in place? And if the answer is yes, there will be harm, then we don't want to have it. Specifically irreparable harm, then we want to keep it in place. Ultimately, they decided that it wouldn't be, and we'll allow it to continue while we have an opportunity to review this fully. So that's what happened.
So many different ways I want to go with this, because you're talking about irreparable harm. So, like, if you say these businesses who may lose money with these tariffs, it's not irreparable harm because they can make the money back. You could do that. But then there is action that has to be taken by those businesses. How would they go ahead and get lost funds? Say this goes through and say it stops in June, but they say we lost $2.5 million. Then would they have to sue for that $2.5 million?
That's what the court would say. I mean, if you can put a dollar amount on it, typically then there is no irreparable harm. And that's normally what the courts would say. And so I would agree with that argument. But when you look at the overarching portion of it, the part that the meat of this, and not the will there be harm or will there not be harm, is the president allowed to do these types of things? I agree with the lower court's analysis, specifically that the manner using that emergency act, there has to be a true emergency. And so if you look at any plain reading of that language, I think that's going to be pretty clear when it goes before the full panel. That panel should come back. And I played that out the other day. I said it will go to the lower court. They'll do an immediate appeal, and I believe that it could be either way. And I thought it would be a panel. I didn't think it would be the full panel of judges. So you had the full panel of judges that allowed this to go forward. But no, I think when it ultimately goes in front of them for the full issue, they bring it back. But you also have some political things in play here. Remember, I talk about cases that go in front of the Supreme Court. You want good facts, good timing, and good judges. Well, you also need to create some hysteria around it. So when the Trump administration talks about these things, you listen to the narrative, and it comes out every time. There are these advocate judges. These are these judges that are trying to go outside the will of the people. If Congress wanted it, these judicial, advocates shouldn't be doing that. There's this major attack, as I've said a number of times, on the judiciary itself. So we're at a really weird place right now as a country where we're trying to see and test the true balance of power. If there is a balance of power, the judiciary's word would stand, or Congress would come in and rewrite the law to make it fit. And right now, the judiciary is trying to take action, but even within the judiciary, there are still some ups and downs that we're trying to work out.
If this does go to the Supreme Court, if they say, hey, the power when it comes to regulating commerce belongs to Congress, you got more Republicans there in Congress, but there were some Republicans that even voted with Democrats saying, hey, we want to stop tariffs. So even if the balance of power goes back to Congress, I guess where it should be, how do you think that would play out?
There's so many ways that this case could go, because before it even goes to Congress, or I should say, while at the same time, because both tracks can be happening at the same time, this case could go to the Supreme Court. Mm-hmm. It could also, this Court of Appeals could kick it back and say, yes, we agree with some of the things you said, but we want the lower court to listen to it again, so they could also do that. And while the case is ping-ponging back and forth in court, Congress could say, actually, when we drafted this in 1977, we didn't anticipate you doing this. And they could actually go in and define what emergency is. If it is ambiguous, if it's unclear, Congress could come and say, well, this is what we wanted to say. But for that to happen, you need bipartisan support. You need both sides to come to an aisle and come together on an issue where I can clearly see them not coming together on. And so I ultimately see this going to the court, and it ping-ponging a while until it gets to the Supreme Court. But when it gets there, I think it gets really confusing again.
Well, one of the things that they could argue, right, is this interpretation of the International Emergency Economic Powers Act, where Congress gave the president discretion to use this power. How could the Trump administration argue that this would fall into it? Because as you said, when you first broke this down, they said, well, you can do it, just not this way.
Yeah, I mean,
how could they argue it?
He'd argue that, look, if I'm arguing for the Trump administration, I'm saying that although this has been in place for 49 years, that those other folks don't understand what an emergency is. An economic deficit is an emergency. I have in my business acumen, I've been doing this for, a number of years as a successful businessman. If that's my argument, I'm going to say that those other folks that have done this don't recognize how this is going to hurt us as a country. Mm-hmm. And because they don't recognize how this is going to hurt us as a country, they didn't look at it as an emergency. But I am saying this is an emergency for not just now, but in the future. And I want to make sure that it doesn't hurt us as a country. That's the only argument that you can make. And that's the argument they've been making. And the lower court just didn't agree with that. While I can understand and appreciate that the deficit is a problem, does it fall under the definition of an emergency? That's going to be the ultimate question. And regardless of where it pings-pongs back and forth, the court has to answer that, or Congress has to define that, but somebody has to speak up.
Seems like there was a former president years ago that said, it depends on what the definition of is. We'll have to see. We'll have to see, Khalif. All right, thank you very much. Appreciate that.